Why is it important to lock a doctor into testimony prior to trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Now, why would I ever want to lock a doctor into his pretrial testimony during a question and answer session given many years before trial? There's a really important reason for that. Let me share it with you. When I question a doctor during his deposition, which is the question and answer session given prior to trial, I have an opportunity to find out from that doctor what was done and why. What was the reasoning behind why he did what he did? Why did he choose this particular procedure? What occurred during this procedure? And I get a chance to ask them specific questions about what he did and why. Now, years later, when the case comes up for trial, I'll have a chance to ask the doctor the same exact questions during either direct examination or cross-examination. And now I want to make sure that if the doctor gives an answer, it is consistent with the information he gave 2 years ago when he gave testimony during the pretrial examination when I questioned him during his deposition. Now, if the answers are inconsistent, I can use those inconsistencies to show to the jury that we're more likely right than wrong, that what we are claiming is true and correct. And by locking the doctor in early on in the litigation process, or any witness for that matter, I've now clearly established what testimony the doctor has, why he did what he did, and now later on, as we get to trial, in all likelihood, he will be prepared, and his attorney will discuss the case with him, and you know what? Sometimes the answers may change. And the doctor will then try and give an explanation about why he's changed his answers from 2 years earlier. So now it gives me a great opportunity to show to the jury that there are significant inconsistencies and that one of the only reasons why he would have shifted his entire answer would be in preparation for the trial, in discussing the case with his attorney, and now to try and get a favorable answer to a particular question. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process and understanding some of the strategies that we attorneys use when evaluating and proceeding with a medical malpractice case here in the state of New York. You know, I recognize that if you're watching this video, you probably have questions of your own. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Have a wonderful day.